Hello once again and welcome to another episode of A Question of Law. This is City TV's legal education program, and here we seek to break down the law as far as it pertains to the daily activities of our lives. Now, the show is interactive. We definitely want to hear from you throughout the show, so use the hashtag A Question of Law on all social media platforms, and WhatsApp line is 0550-585832. My name is David Kwekusechi, and you're welcome to A Question of Law. Welcome. Now, my guests are already seated, and so I'm very excited. A conversation we're going to get into things that have been in the media space in the last few days, and rubbing different people, differently. Some people are agitated, other people are very excited, and so on. Well, I have with me today, for the first time, Senor Ajabeng, who is a labor consultant, and also I think this is the second time he's here, Kenneth Coomson, Deputy Secretary General for the Ghana Federation of Labour. Gentlemen, you're welcome.
Thank you.
All right. So let me just quickly set the stage by reading a quick article from citynewsroom.com. It says here, the headline says, 36 public service groups also demand political neutrality allowance. Now, I'll just quickly read a couple of paragraphs here. 36 organizations under the Public Services Workers Union are making a strong case for the payment of political neutrality allowance for qualified members. Now, the groups are demanding urgent action for the allowance to be paid following a similar call by some public sector workers under the Civil and Local Government Service Staff Clocks Act. All right. Let me just come to Ken. Where did this political neutrality allowance emerge from?
Well, thank you very much. I think it's quite important that we lay a very good foundation, a premise for a conversation that will give clarity to public curiosity.
Okay.
Civil servants, servant to successive governments, ministries, department, agencies, across the country, from district to the national. And this system had been there during the colonial administration. So they serve the government. So by virtue of their job profile and description, they ought to serve.
Yes. Without
being politically inspired. So the fundamental thing is that this is your job description.
Yes.
But what we recognize over the period is that this is a group that have been disadvantaged over the period. And this is because when Nkrumah took over, 1957, an act was passed.
Okay.
That was the 1960 Civil Service Act, 1960, that came along with the LI 47.
Okay.
And actually defined the job and the kind of responsibility that exists for the civil service or the civil servant. Many years passed and that act was amended by the PNDC regime.
Okay.
Passed a law, the Civil Service Act 1993,
okay.
PNDC Law 327. And if you look at section 66 or the provision 66, in that act, it provides an interesting clause that was to say that when it comes to matters of conditions of service of the civil servant, it ought to be either a regulation or an administrative instruction.
Okay.
So the act did not make provision for the terms and conditions of service. It deferred the determination of their terms and conditions of service to a regulation. And in law, Article 11 of the Constitution, the regulation is a deed or act of the sector minister.
Okay.
The question you and I have to administer is that, do we have that regulation? But what you must understand is that it said either a regulation or an administrative instruction. The question that arises is that, do we have an administrative instruction? Yes, we do have it.
Okay.
Now, that administrative instruction provides some conditions of service, not a total condition of service. But what CLOSAC is saying is that they have, over the years, been denied their conditions of service, which is a condition that regulates and determines the terms that must govern the parties, compared to NAGRA, the teachers, the other public service institutions. For which reason they made a case. What has become the misleading information in the public domain is the nomenclature.
I see.
The nomenclature, if you want to go according to the literal interpretation of the nomenclature, neutrality allowance, then it violates Article 94, 3b of the sovereign law of the land.
Which says what?
Which says that once you are a civil servant, you are not expected to become politically motivated. You don't have to take sides, because your loyalty and fidelity stands with the government.
Okay.
So how then do you want to be involved by the immigration service, the police service, and other services? You are supposed to serve the country. So it is a fundamental job description that the Constitution lays clearly. But the issue for me is that, how did they arrive at the name neutrality allowance? And I believe my colleague comes in, we will get into that, and then give a certain background, whether or not it is CLOSAC members, it was government, or who came up with the name, and what actually induced the description of their allowance, which was actually supposed to mitigate the strain and the stress in the economy. And the question of whether or not the condition of service that is absent is a matter to be addressed.
Okay, so why does it even exist? Why did it come? I mean, Ken says it's a misnomer. It's something that should never have been used to describe the particular allowance. How did we come by this?
Well, parties to a collective agreement, because CLOSAC is a union, and their employers, the Civil Service Council, for example, they have the right to agree on the terms and conditions of service, actually to negotiate, right? But under the circumstances, it's a gray area to say that the names of the allowances or the benefits that public or the civil servants are supposed to get are cast in stone.
Okay.
So it is quite flexible. But I think that what happened is to ask the question, currently are civil servants justified to ask for, or to have asked for, a raise in their salaries or condition of service? And everybody knows that it's a yes. I mean, I don't think anybody will say under the circumstances they don't have the right to. But I think that the problem that occurred was to use this, call it nomenclature, to resolve the issue of enhancement in pay. And that is where the problems come, because it opens a Pandora's box. For example, the labor law requires that workers within the same kind of grouping and class must be paid the same wages, okay, equal pay for equal work. Section 68 of the labor law. So if you remove one party and set them down and issue or introduce a new allowance, then others like them are justified to call for that. But I think that the main issue that CLOSAC are raising, that it is, you know, at law, it is only them that are barred from actually being political or participating in political activity. The rest of the public services are regulated by their internal conditions of service that bar them somehow from that. But I think that there's even a ruling, a Supreme Court ruling, that allows public servants to be able to, in as much as they would, leave the job and go and concentrate on that, and they can come back and all of that. So we are here now with a new nomenclature, a new, on top of all the other public sector allowances. This morning when I was counting, it was about 45.
Wow.
Yes. If you look at the allowances from the class 1 allowances to the class 4 allowances, they are about 45. This is a new introduction. But I do not think that it is wrong in the sense of the word, as in the right to introduce new allowances or to enhance pay. But where you use a name or you use a description, that makes it difficult for you to apply to only a class of workers. That is where the problem may be coming from.
What should we have called it? Or what should they have called it?
You see, I tell you what. The name Neutrality allowance came from government.
Okay.
Because in that meeting, we are informed that Fair Wages and Salaries Commission represented, the Ministry of Employment represented, and that name actually came from government.
So wait, you're saying that government proposed an allowance?
So it is not about the proposal of an allowance. It's the fact that there is a deficit in the conditions of service, because the civil servant, as of today, do not have a condition of service like any other employee whose fate is determined by an agreed conditions of service.
They don't have one.
They don't have it.
Okay.
So for the past 3 to 4 years, there's been an attempt, because after they secured their collective bargaining certificate, the next thing to do is to engage in negotiations with a view to have a collective agreement or a condition of service. The question we have to ask as Ghanaians is that the civil servant gone to school, finished his first degree, his master's, his PhD, occupying such a strategic place in governance to ensure that the government of the day is able to prosecute his plans, his agenda, his without fail. How should we handle such a person? And if such a person is saying that I do not have a condition of service, the material question for me is that, is it true or false?
Okay.
And if it is true, why is it so? And if it is true, what can be done to put in place a condition of service that will guarantee their job security, just like any other person? So the issue of neutrality allowance is just a drop in an ocean. Whichever way you want to look at it, the issue for me was that it could have been called, or they could have agreed that this is a salary increment and give it 25% or 20% based on the current inflation. That for me would be the ideal way to describe it, or inconvenience allowance, just as all the conditions of service in this country has a term called inconvenience allowance. So we should be very careful in our attempt to make closer knit members across the country appear as though they are making unreasonable demand. It's a question of the form against the substance.
Okay, but in this case, people, all the hue and cry that's going on in society, I think is justified in the sense that the Constitution says that you are not allowed to engage as a civil servant in political...
That is not in contention at all.
Okay. So if that's the case, and you say, I still want to be a civil servant, you know what you're getting into. So why are we now remunerating you for being neutral?
So that's why we're saying that there is a misleading impression. The nomenclature has actually misled almost all of us into thinking that the argument is about somebody demanding for what legally is unacceptable.
Yeah.
That name came from government.
Okay.
It is not the CLOSAC and its members who suggested to government.
Okay.
Because in negotiations, you and I know, I get to the table, he's sitting there, I'm sitting there.
Well, we may not really know what happened on the negotiation table.
I am telling you because I'm preview to the discussions that transpired.
Okay.
So I'm not talking as a fringe. I'm telling you as a leader of the workers in Ghana that this is what transpired.
Okay.
I am not, that's what I'm telling you.
Okay.
So in negotiations, things happen. And government recognizing that indeed the concern of CLOSAC is genuine. These are the guys who work with us, who take minutes, who do the reporting for us, who do all the business for which any minister will be credited and will be awarded of having discharged his duties creditably well. How do you manage such a person? And you have met with them and decided that we are going to give you what we call neutrality allowance, for the want of better expression from government. Today, CLOSAC has to be held responsible, liable for a nomenclature that it creates.
Okay.
So what I'm saying is that the challenge, or what I feel CLOSAC should have done, was to have rejected the nomenclature that was adopted and said, this is not what we are asking for. We are asking for a total overhaul of the terms and conditions, and make us also, and listen, they are on the single spine. In the single spine is a salary structure. I give example as this building. You have a ground floor, and then you have the upper floor. You may have the CEO at the top, and then you might have the lowest person at the bottom. CLOSAC is saying that even on the salary structure, that is it, sometimes they use these words to confuse all of us. It's a structure. They are on the ground floor of the structure.
Wow.
And the ground floor has the rooms. Room 1, room 2, room 3, and that's what we call the scale.
The scales.
So what I'm saying is that there's a genuine problem. We need to investigate, interrogate, and come out with something that will help us ensure that our hard-working civil servants are compensated for the hard work they put in. I've heard people making all kinds of analysis that they are counterproductive, they are not working. Come on. What is all these things from? That once it comes to the compensation of an employee, suddenly we find a way of working the public against us. No, I don't think it's the way we want to go. These guys discharge their duties well. If you have a measure to determine productivity, let's discuss the measure. Let's discuss the element that goes into determining whether somebody has produced or is not produced, whether it's been productive or it's not been productive. Let's discuss it.
You know, I hear you. I hear all that you said. But point is that I think the parties deviated from the norm. Normally, how these things are done, other than because there was already an agreed salary increment for the year, and so normally how this is done in the past is to agree on what we call a COLA, a cost of living adjustment, which is normally a one-time, amount or a percentage of people's basic that is just paid to them, just to cushion them for the year while preparing for negotiations for the next year to correct all the relativity problems that would have occurred. And I think that has been the strategy that has always been used, where you are hit by sudden economic conditions that affect workers like we are facing. So it's strange to some of us where this came from. And as Ken said, the union should have found a way of disagreeing and not accepting. Because now it is as though they've agreed to something that is not conscionable, that is not, it is lawful because it was agreed and signed, and now it is as enforceable as law. And that is what CLOSAC is seeking to enforce. But somehow, generally, it doesn't sit well with ordinary Ghanaian like yourself and myself. So going forward, one of the things that I believe we should look at is going to renegotiate and see how, because agreements are made by people, they are amendable. They can always be amended. And so maybe it should be looked at again. But if reality sets in and is actually implemented, which we pray that it's not, because they should solve these problems before we go on. It will open a Pandora's box, and we may end up spending more money than we actually thought of spending, because everybody will come and get a piece of this cake.
No, I mean, there are 36 others who are in the wings, waiting to get their
But
share.
you agree that it should be paid?
Well, I have said
It should be
over
reconstructed.
again
It should be,
that the nomenclature that was adopted has actually created an impression non-existing.
Yeah.
These guys deserve a total compensation, benefit and compensation. They do not have conditions of service. That is a fact that government has admitted. Who is the employer? Who am I to impose a condition on them?
Yeah.
So in the absence of condition of service, what do we do? And that is when I'm saying that when you begin to talk about neutrality allowance, it is not even sufficient in the first place. It is only the nomenclature that is misleading people to assume that these gentlemen are making demands which are unreasonable.
Yeah.
That allowance could be called inconvenience allowance.
Okay.
It could have been called any allowance that we have for the CEOs, for those occupying, those on the Article 71, and those of us who are in the enterprises, so on and so forth. There are several allowances. You could use COLA or any other terminology you want to call it. So what I'm saying is that where we are sitting today, we need to make Ghanaians understand that what actually resulted in the demand for an allowance to cushion them, to become more like a bridge for which they can wait until a full condition of service is signed, was what government decided to call it neutrality allowance and not the workers say. It must be clear. So government now has the burden to explain to the people of Ghana why they came up with that name, and whether they were compelled by the other party to adopt the name. I'm sure society would want to know.
What time period did this happen in? I understand Osafo Mafu was minister at the time. Or am I getting the facts wrong?
Yes, I show which I think is last 2 years or something. We could verify and then be sure of exactly when this decision was taken. In fact, government has agreed to pay in October. We are saying that there should be a signing of collective agreement, conditions of service, to make sure that the civil servant, a distinguished servant, is treated well. I mean, you know the word servant.
Yes.
That is what it is. That's what it has been from the beginning. So these guys were not entitled to condition of service because the mindset was that you are servants. We are qua. And that is the reason why. So it's not about MPP government or NDC government. This thing has been there for years. So it's just for us to know that in order for government to succeed, you need a very functional system. You need a motivated staff. You need people who can help you prosecute and achieve your agenda. And these are the guys who work with you. So for me, it's just like going to the maternity ward and then meeting the midwife and treating her badly. You are likely to have you know what I'm talking about.
But let me correct something here. You can't keep saying civil servants don't have conditions of service. Conditions of service basically are rates of pay and other resources that employees require to work. And we have the Public Services Commission that has its guidelines on how public sector workers should be taken care of. And then that led also to an additional body, the Fair Wages and Salaries Commission, that runs a pay administration based on the general conditions of pay that are applicable to all public sector workers, including civil servants. So there is a structure, he mentioned it, there's a structure, there are conditions that are applicable. But when unions form and they get a collective bargaining certificate, they sit and they negotiate a collective agreement. Maybe it's that document that is not there and that he may be referring to. So there are conditions, all right. Maybe they don't have their own distinctive signed conditions in a collective agreement as per the other public sector unions. So, yeah, I agree with him in part, but at least we needed to make those distinctions.
Yeah.
You want me to rebut him?
Well, I don't need you to rebut him. We're trying
We
to
don't
educate
have
ourselves.
conditions of service.
At all?
That is what I'm telling you. If there is one, just produce it. And that will be the basis for analysis, because I am interested to look at.
But they are paid something every month on a particular basis.
So you see, there are two.
Okay, we have to take a short break.
Getting
Right? So,
interesting.
yeah, I know. We'll definitely continue the conversation. So we'll take a quick break. Don't go anywhere. We will be right back.
City TV is live on DSTV. Go to channel 363. On GoTV, access City TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access City TV on your television. City TV can be accessed on a free-to-air digital box like the GoTV and Star Times box. City TV, it's your world.
All right, welcome back. It's still a question of law. The hashtag is a question of law on all social media platforms. The WhatsApp number is 0550585832. We do want to hear from you. Do send us messages regarding the conversation that we're having here. Maybe you are with any of the different groups and you have an opinion on this matter. Do share with us. We'd like to hear from you. All right. Well, Ken, you were making a submission about the fact that there are no conditions of service, and we wanted to clarify something.
Well, I think that my colleague made an intervention which I needed to rebut it swiftly.
Okay.
And that is to say that there is every employee employed, the first thing you are handed is your appointment letter.
Yeah.
When you go to the civil service, most of these arrangements are the issuance of appointment letters.
Okay.
Which has a certain minimum condition of service, but does not exhaustively consider the mainstream if you are doing a benchmark with other public service employees.
Okay.
So it has become like what we gave you prior to your appointment is what we stay with.
Okay.
But we all know that in reality, the content of the appointment letter is something very insignificant, and you cannot actually refer to it as a document that the employee participated to tell you that this is not good or it is good. It is at the discretion of the employer to give you an appointment letter. Yeah. So what we are saying, and I agree with him, that yes, with the collective bargaining certificate issued to CLOSAC, the law imposes an obligation the parties to conduct negotiations with a view to arrive at a condition of service. That is what is absent, and that is what for which there was the demand for a COLA or a stopgap measure to cushion them, considering the economic issue. So that, for me, is the angle with which the society should look at, and not Article 94(3)(b) that requires neutrality, and for which reason, if you cannot be neutral, then you must pack your bag and then leave. That particular nomenclature was induced by the state, and government perhaps may want to explain the rationale behind resorting
or
to
may
that.
want to reconsider
and rename it,
rename it or reorganize it, restructure it.
I agree.
And then, because the need is there, except the application is the problem.
The issue. Okay, well, speaking of negotiations, we have an article here on citynewsroom.com. It says here, adjust public sector salaries to match rising inflation. All right, TUC is urging the government. Again, I'll read a couple of paragraphs here. The Trade Union Congress wants government to increase salaries of public sector workers to match recent inflation figures in a bid to cushion them from current economic hardships in the country. Now, latest data from the Ghana Statistical Service says significant increases in the prices of prices associated with food, transport, and housing have pushed the national year-on-year inflation from March 2022 to 19.4%. Now, the rate is 3.7 percentage points higher than the 15.7% recorded in February of this same year. All right. So, let's talk about this matter as well. Now, we're looking at TU is saying the minimum wage too small. Let's increase it to match, what inflation has already done to us, right? What does the law say as far as this is concerned? Can, at any point in time, can we just be adjusting, salaries and all of that?
Well, yeah. The labor law gives a right to parties to make proposals during the course of employment, especially where they are covered by a collective agreement. Sometimes in the collective agreement there are specific clauses that say wage opener clauses. We call it wage opener clauses, where the parties come and then negotiate. But in emergency situations where a party feels that there has been so much dire economic hardship or sudden changes, that makes it urgent for the already agreed, negotiated conditions to be relooked at. You have the right, because it's a relationship. Indeed, the labor law requires that the parties agree in good faith, the conditions of work and also pay. So yes, the right to request for or to propose for a renegotiation is right. And indeed, in Section 104 of the labor law, where a party makes a proposal, the other party has 14 days to respond. Otherwise, they have a right to be able to cause the Labour Commission to make the order for the parties to go to the negotiation table. But you see, there's something unique about salary increments in Ghana. Often, we tie it directly to inflationary figures. And that is where the problem is. Because inflation is basically reflecting devaluation of money over time, right? And so if I give you a salary increment that matches inflation, it means that I've just restored your salary
back to where it was.
Yes, I've just restored the value loss.
Yeah.
But I've not actually
giving you extra value.
Okay. So what normally we call a salary increment is often salary restoration or salary value restoration. So if under the circumstances or any circumstances, you do not increase salaries up to inflationary levels, then the employee loses a double. Because you are supposed to restore and then create more value. That is when the employee can be seen to be gaining. Well, that is the fact of salary administration. So in this case, where salaries agreed was around 7%, and for the year, and we just started the second quarter, and inflation has hit almost 20%, 19.4. It is
in a month, it jumped almost 4%.
Exactly. It is an extremely difficult situation that justifies a relook at the conditions as they are, upping the agreed, negotiated, amounts for employees. So yes, it is a rightful and lawful request to make.
But what are the laws or the legalities surrounding negotiations? I mean, who initiates the negotiation and all of that? I mean,
so thank you very much, Senor. I think Senor hit it right on the head. I'll give you a background. In 1928, the International Labour Organization promulgated the Minimum Wage Convention, because the minimum wage has a legal framework within which we need to discuss within context. Ghana by then was not a member of the International Labour Organization. But when the colonial masters were here, in 1939, we are told that they were using that convention of 1928, which was passed at the ILO. But at that time, it was just the masters who were determining and imposing on their staff. There was nothing like tripartism. There was nothing like 3 people meeting to discuss: employers, government, and then employees. 1957, after we gained the independence swiftly, then Nkrumah became worked out to get Ghana to become a member of the International Labour Organization. As soon as Ghana became member, then we ratified that 1928 Article 26, Convention 26. That means that from 59, we were supposed to now engage the tripartite as per the ILO Convention, because the minimum wage convention has the force of law. It's not persuasive or a recommendation by the International Labour Organizations. And you must understand that the ILO is made up of government across the world, employers across the world, and labor across the world. In June, the parties will be there to review new conventions. And once you sign to it, you ratify it, you come in. There's a process for which Parliament must ensure that it becomes part of our domestic legislation.
So by law, government needs to sit with employers and employees
to negotiate.
Yes.
That is the Convention 26, 1928. But see what is happening. In 1970, there was a new convention, also known as Minimum Wage Convention, that amended the previous one. That provided a criteria, an established element for determining minimum wage. One is, what is the need of the employee and his family? Currently, when we talk about minimum wage, we are only negotiating considering an employee.
But not his family.
I see. So the minimum wage determination only considers an individual. So if you have a family of 4 or 5, that is your business. That is what the current law.
Yeah, but what's wrong with that? The employee is the one who came to work, not the family.
You ask a question and I give you a very simple answer. You must understand that in this country, across the world, we are all family members.
Anyway.
You went to school because your father could provide you education. You are here because somebody supported you. So you cannot, as per the internationally accepted upper poverty machinery, consider an individual as constituting the family. And that is why the ILO said an individual, an employee and his family, and that is adopted by the parties. So when you come to Ghana and you are negotiating on minimum wage, in your negotiations, you consider the need of the employee and his family. And what is the need? Education, shelter, food, and so on and so forth. Today, we are talking about the cost of food and how it's rising exponentially. So what we are saying is this. In 2019, the Honorable Minister of Finance went to Parliament and said this, it's on record, that we recognize the disparities, the inequalities that exist between those on the single spine and those outside the single spine. For which reason we are saying, Mr. Speaker, the government is going to work aggressively to break the gap. Soon as that was done, we were very hopeful, excited. And then we began to jubilate that yes, there's going to be drastic measures to overturn the development. Then in 2020, minimum wage said 12% for somebody who was earning 300 Ghana cedi a month. And then the base pay was 12%. 2020, after that parliamentary encounter. Then in 2021, you go and negotiate, and they say that they will give you 4%. And then for the base pay, minimum wage 6%, base pay 4%. In 2021, minimum wage 8%, base pay 7%. Now the question we ask is that what has been the percentage rise for Article 71 office holders, CEOs of state-owned enterprises? What has been the percentage? And we said, as soon as we agreed to the 4%, it actually occasioned a certain sporadic reaction from our members when they got to know that Article 71 public office holders were given 70% pay adjustment. The question we ask, and that's a critical question every reasonable Ghanaian should look at. What inform that percentage? What are the variables? What are the elements?
The 70%?
The 70%. Okay. Then when you come to the CEOs, 35%, 40%. And we are saying that what are the indicators, the variables that was used in determining this pay rise? Because, my brother, the normal practice, the sound acceptable practice is that the one who is on the top on the salary structure, in terms of percentage rise, take less than the one who's at the base. So if the one at the top is telling you that I can take 70% or even 15, 20% and give you 4%, what does it tell you? It means that there's resources available for which we can be compensated. But listen to the rebuttal. Oh, they are too big. They are the numbers. They are 700 employees. And those 700 employees are consuming about 50% of the revenue that government mobilized. And we are saying these 700,000 people are not, robots. These are human beings, professionals with skills and competence, delivering, producing results. So let's deal with this case by case specificities and don't lump the people up and make it appear as if they don't deserve. So what we are saying this year is simple. There's a formula for determining minimum wage. We've used that formula since time immemorial. And the formula is simple. Current inflation, projected inflation, and then we do the nominal value, the GDP calculation, and then we go. I've been a member of the tripartite years. So what we are saying is that if you look at the 7% that was given last year, with inflation terminating at 12%, we have a difference of 7, 12, you have 5%, 5.6% as our restoration value, and which Senor mentioned. So already there is a restoration element that has to be restored for last year because you gave projected, because government project the inflation and tells you that this year inflation will terminate at 8%. We agreed. We ended the year and the inflation was 12.6. Meanwhile, you gave 6%. So what is left to be brought forward is what? 5.6%. That is the restoration. Then we have the formula says, now projected inflation. Now as we speak, the inflation is 19.4. And there is a copious evidence suggests that if you look at the food items within the basket, the prices are going to increase. We won't be surprised that by December 2022, we'll have inflation around 30%. We are doing our forecast and saying, on the basis of science, not conjecture, 20% will be there. The least that organized labor deserve to compensate for last year and to provide a hedge going forward.
So what I find interesting in all of this is it seems that, I mean, you brought up something that I think it has never really occurred to me, that in the same public sector, there are those that have their, but do they negotiate for this, 71 article holders? Do they negotiate?
No, they don't. It is determined by a presidential commission on compensation.
So why are we not doing the same for everybody else?
So one of the key pillars of salary negotiations I've mentioned is good faith. Another one is equity. Okay, and that's what I quoted the labor law in section 68 to say that equal pay for equal work. And if when the public services and salaries are being determined, normally the scales have to be adjusted such that the relativities between the various classes are maintained. Sometimes the presidential commissions use other factors and discretion to determine pay, and that is why there's normally a difference. While for the Article 71 holders, you're using a presidential commission, you are the tripartite committee is doing minimum wage, and then the public sector standing joint negotiation committee of the Fair Wages and Salaries Commission is determining the base pay for public sector workers. Right. So the different institutions of negotiation or of determining of pay in the public sector can affect the kind of, and that is why a few years ago I heard certain suggestions that we should unify the body, like set up an authority that determines public sector pay across the board from the top to the bottom, and that would possibly resolve the issues. But you see, in negotiations, you asked which party starts the negotiation.
Yes.
Normally, the unions will make the proposal, and then the management side or employer side, in this case in public sector is government, and government agencies would look at it and then make counter proposals, and then they come to the bargaining table, and then they judge all. We call it they negotiate, and then they come to a settlement. When they come to that settlement is signed off and is binding on the parties. And that is the structure. But while doing this, the law requires that in all of the dealings, they have, for example, ground rules for which they will follow. And then beyond the ground rules, they need to have dispute resolution mechanisms, that ensure that any disagreement they have during the negotiation or even in the course of their relationship, employment relationship, are resolved. The disputes that occur are resolved. So these are the main issues about negotiation and negotiation
just
structure.
Elaborate a little bit on negotiations and principles that guide negotiations.
Yeah, so that's what I've said. The key ones is the fact that parties must have, for example, ground rules to negotiate. And the ground rules will mean that what happens amongst us should, for example, be confidential. That's an example. Then, apart from the ground rules, the parties need to act in good faith. And in good faith means that they should look out for each other's interests while they are, so that both would win, both would gain. Then, I've talked about confidentiality and then a binding agreement. They have to sign off. These are the key principles. Problem is that sometimes the issue of good faith becomes a challenge. And the parties look at their own interests and therefore do not get to that point where they can come to a firm agreement. But it's something that is doable because once they continue talking, they can always get to an agreement. And that is why I think that the issues of the strike that is going on and all that are all salary-related matters, and they can come to a firm agreement, restructure what is happening so that there can be peace.
If government says, Ken, that there's no money, what are you going to do?
Essentially, there is the need for, if I tell my kids that there's no money at home, and I like for us to relate, the children are only able to measure by my expenditure pattern, my conduct, behavior. That's the only true measure.
That they will now believe that it's true.
If they see me at some sports with friends, with some bottles,
but they say
chewing pop.
But it's my friends who are spending the money.
So even if it's your friend, it means you have identified yourself with a certain class for which you recognize that is good. So what we are saying, government must just demonstrate by example, so that we are not heckled as leaders of workers. We are not threatened, because last year there were litany of threats over the 4%, which the following week, Article 71, office holders announced a 70% pay rise. So the conclusion was that these guys have been bought. Nobody buys me, not NDC, NPP. My loyalty is to the people. If anybody has given me any money, come and say it or show it. So what I'm saying is that by virtue of the decisions and the profligate expenditure that we see, communicate a certain impression to the ordinary person that we are being shortchanged, and the leaders of the workers become the target. So it's simple. Let's provide leadership. and we all build a country that tomorrow all of us can be happy. But if until that happens, the pressure will keep mounting. We will not sleep in our homes. We'll be hiding in places, and that will not be good for us. That is for which reason we speak with this level of passion. Yeah. It's not because it's about CPP, MPP. We don't give a flying figure about any political party in office. Our concern is that a country built by Ghanaian workers ought or needs to be compensated in a manner that they can continue to contribute their best for economic development. That is it.
You see, it's a tight situation.
Yeah.
But in negotiations, nobody can go to the table without any resources. You can't go to the table and say, I have nothing to offer.
Yeah.
So for you to say that one party or the employer side would say that there is no money, I don't have money, it would be difficult to sell on the negotiation table. So something must be found for workers to be cushioned, because indeed the situation is dire. Otherwise, there will be no peace, because I don't see workers actually relaxing about this. And there'll be threats of strike, continual strike, and it will not get us anywhere.
It's true.
So that something must be done as to what it is and what our leaders should look at and really put in place.
All right. Well, gentlemen, it's been exciting. Thank you very much. We had a good conversation.
Thank you.
And let's take a look at our legal trivia for today.
Legal trivia. Did you know that a worker shall be given a rest period of 48 consecutive hours in every 7 days of normal working hours? And the rest period may, for preference, start from Saturday and end on the Sunday following, and shall, wherever possible, be granted to all of the workers of the undertaking? This can be found in Section 42 of the Labour Act 2003, Act 651. That will be all for our legal trivia today.
City TV is live on DSTV. Go to channel 363. On GoTV, access City TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access City TV on your television. City TV can be accessed on a free-to-air digital box like the GoTV and Star Times box. City TV, it's your world.
Welcome back. And it's been exciting, this rather fiery edition of A Question of Law. I want to say a big thank you to my guests who have joined me this morning. Thank you very much, Ken, for taking time off your busy schedule to join us here in the studio. So, it looks like we found another guest who is going to be joining us from time to time. So this is exciting. Thank you very much. I hope you guys have enjoyed today.
Yeah, sure.
You've enjoyed it today?
It's good.
Yeah?
Thank you.
All right. Fantastic. Thank you very much. Well, thank you. Yeah, fantastic. So thank you too for watching, and keep watching City TV. We have all fantastic programming for you. This has been A Question of Law. My name is David Kwenkusichi. Keep watching City TV.